the property management industry, fair housing offenses are considered especially troubling. In the United States, a dedicated fair housing attorney, Leslie Tucker, provides case explanations and best practices. These are some cases.
Hello, everyone, and welcome to the Fair Housing Insiders Case Files. I'm your host, Jonathan Saar, and today we are diving into a case that demonstrates how platform policies and listing practices can inadvertently lead to Fair Housing Act violations. Joining me is Leslie, our expert fair housing attorney. Leslie, welcome.
Thank you, Jonathan. I'm ready to break this case down.
Yeah, interesting one. Today's case is United States versus Airbnb. Very popular group all of us use for planning vacations and doing things. This case highlights how policies that limit access for families with children, particularly through platforms like Airbnb, can lead to serious fair housing issues. Whether you're a property manager using these platforms or managing policies directly, this episode is for you. So, Leslie, can you give us an overview of the case?
Sure. This case involves a couple, Charisse and Christopher, who sought to rent a property for Charisse and their 3 minor children for about 3 months or so, while they transitioned from their home in Huntsville, Alabama, to their new home in Hawaii. So Christopher went to Hawaii to search for housing, find a new job, and Charisse stayed back in the Huntsville area so that the children could remain at their school and see their friends until they finally moved away. So Charisse found an Airbnb listing that she liked, which stated that the property was not suitable for children and infants. At that time, her kids were 9, 11, and 14. So when Charisse inquired about renting the property, the host denied the request and reiterated the fact that the property was not suitable for children. Charisse came back and she said, "Look, my kids are not infants. All they do is play video games and sit in their rooms. This is not a problem." She also said, "Look, it's illegal to discriminate against families with children." But the host allegedly refused to change his stance. She reached out to Airbnb's customer support. They also backed the host's decision, citing the platform's policies that allow the host to exclude children from their rentals.
Okay. So both the property host and the Airbnb platform played roles in the alleged discrimination?
Yeah, that's right. The Fair Housing Act prohibits discrimination based on familial status, including policies or practices that make housing unavailable to families with children. So by enforcing the host's rule, Airbnb contributed, allegedly, to the denial of the housing.
Got it. So let's unpack the legal framework here. What does the Fair Housing Act say about familial status discrimination?
The FHA protects families with children under the age of 18 from housing discrimination, which makes it illegal to refuse to rent, imposing different terms and conditions, creating policies that effectively make housing unavailable to families with children. So in this case, the government is arguing that labeling a property as not suitable for children violates the act. And a blanket rule like this disproportionately impacts families and thereby limits their housing options.
Got it. Okay, good reminder for our audience. So what about the platform's role in this? Could Airbnb have liability here?
Yeah, I mean, potentially. Who knows what the outcome of this case will be, but by providing hosts with tools to exclude families and enforcing those preferences, the platform could potentially be held accountable for enabling these types of, allegedly illegal practices.
Mm-hmm. Got it. So I think there's maybe a big issue we haven't mentioned yet. Doesn't the Fair Housing Act apply to housing where people reside? In this case, Charisse wasn't moving to this property permanently, only for 3 months or so. So why does the Fair Housing Act apply to this situation?
Yeah, that is a great question, and really, really important when analyzing these types of cases. The Fair Housing Act applies to any housing that's considered to be a dwelling. Okay, that's kind of the operable word here. So, what's a dwelling? You really have to look at, or analyze these types of cases on a case by case basis, because there isn't a kind of concrete outline as to exactly, what situation everything falls into. You have to look at it individually. Here are some factors that courts consider in determining whether housing falls into the category of a dwelling. One is, do the occupants maintain the premises? Do they clean, themselves, or do they have someone cleaning for them? Do they cook their own meals? Are they spending time together in the common areas of the particular property? Another is the length of the stay, obviously. There's no specific time limit that's required when you're considering, is something a dwelling or not. But obviously, a 2-day stay versus a 2-month stay is relevant to that, to the analysis. Another was the absence of another residence. In other words, does this person live somewhere else and they're just coming to, stay very temporarily at this other place? In our case, the woman had already sold her house and was renting this as a place to stay in the Huntsville area. And lastly, the nature of the stay. Okay, why are they trying to rent this place? Courts specifically contrast a dwelling with, a temporary vacation or a transient visit. They kind of make that very clear distinction between those two things. I certainly think that there are multiple factors present in this situation that could lead to the conclusion that this housing, it was not just a vacation, but rather that they intended to use the rental as, a dwelling, even if it wasn't a permanent situation.
Yeah, good points. Short-term housing's become a very hot topic in our industry over the last few years. So thanks for the explanation and the details for this one. So a question that we hear often is, what if a property truly isn't child-proof? For example, a unit with an open balcony or dangerous stairs. Can that be used?
I completely get it. And that's a very valid concern. And certainly, the fear of liability is what probably led to this entire situation in the first place. Mm-hmm. Property owners can and should disclose specific safety risks that exist at at their properties, but they can't use those risks as a blanket reason to deny all families with children. Instead, they should, make them aware of the risks and allow the families to assess those risks that are present and make informed decisions about the property for their household.
Got it. Okay. So then what about platform-specific tools like check boxes that would use a phrase, not suitable for children? What's your thoughts?
Yeah. And so a host can just sort of check a box that this is what they want in their listing, not suitable for children. Using tools like that can be very, very risky, as we see in this case. Right. Property managers should ensure that any criteria related to children that they are listing in any marketing or online listings or however you market your properties, anything related to children or excluding children can only be applied to properties that have a legitimate exclusion. These are properties that are covered by the Housing for Older Persons Act, or HOPA. If you don't know if your property is covered by HOPA, it's probably not. But if you're unsure, if you have questions, certainly consult with an attorney and ask. But those are the only types of properties that are permitted to exclude children.
Got it. So thank you, Leslie, for breaking this case down, and great practical advice for our audience again today.
Yeah, glad to be here. Thanks, Jonathan.
For our amazing listeners, we thank you again for taking the time out of your day, your professional day, your busy day, to check out this episode of Fair Housing Insider's Case Files. And if you found it beneficial, helpful, please share it with your network, subscribe to our channel, and give us a thumbs up for this episode. Until next time, take care, everyone.